case briefs, and so much more. LSData's got what you're looking for.
In a dramatic courtroom saga, Mrs. Bass, a church attendee, was run over by fellow church member, Mr. Kenneth Fussell, while engaged in prayer in the church aisle during a crowded service. The accident led Mrs. Bass to seek damages against Aetna Insurance Company and Southern Farm Bureau Casualty Insurance Company, the insurers for Mr. Fussell and Shepherd's Fold Church of God. The lower court dismissed her lawsuit in a twist that brought both negligence and the legal precepts of assumption of risk and contributory negligence into focus. The decision, however, was not the final say in the matter. The Bass family appealed to the Supreme Court of Louisiana, committed to the belief that their case was sound. In a decision that rocked the courthouse, the Supreme Court found that Mrs. Bass was not contributorily negligent and had not assumed the risk while praying in the church. The evidence presented did not sufficiently demonstrate that Mrs. Bass was aware or should have been aware of the risk of being run over, nor did she voluntarily expose herself to such risk. Reversing the decision by the lower court, the Supreme Court ruled Mrs. Bass entitled to damages, a victory that placed the financial burden squarely upon the shoulders of the defendants. Deeming it beyond their jurisdiction to calculate the damages, the Supreme Court remanded the case back to the Court of Appeal. The final settlement figures were left in the lower court's hands, but one thing was clear: the insurers would bear all associated costs.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.